Hi drivers, Paul Taylor once again from Truckers Justice Center. We're continuing our series. This is part 6, Anatomy of a Whistleblower Lawsuit. Last series or last video I talked about how we write up a charge to file with OSHA alleging that you were retaliated against either through a false information on a DAC report or an illegal firing or transfer or demotion or pay reduction in retaliation for engaging in some sort of activity done to advance safety, either refusing to break a DOT regulation or making safety-related complaints. So once we file the charge with OSHA, OSHA is going to assign an investigator. We're going to get back an acknowledgement letter acknowledging that the complaint was filed. We file it by fax, so we have a record, and we mail it in, and we send a copy to you. And then OSHA assigns an investigator. And depending on which part of the country you're in, the case is going to be at OSHA anywhere from probably 6 months, and I hate to tell you this, in some cases 4 years. Typically, OSHA will assign an investigator, assign a case number, and ask for a statement from you. And usually the complaint that you've worked very closely with our staff, either with Cassidy behind the camera, Peter, who's sitting over there behind me, Wesley, who's out today. He went off to take care of some matters at home, let him off early today. And we're going to take that charge we wrote up for you and turn it into a statement that you sign. OSHA, the investigator, the whistleblower investigator, is going to come back with perhaps a position statement from the other side and at least see what kinds of things can we agree on. And OSHA is going to make an evaluation. If they think they might rule in your favor, which doesn't happen a whole heck of a lot of time, luckily we have another level to go to, but if OSHA investigator thinks he's going to recommend that you win, that he finds that there's probable cause to believe that you were retaliated against for refusing to drive in violation of a DOT regulation or for filing safety-related complaints with your employer or the government, he'll perhaps come back to you and ask you for evidence of damages. Of course, we want the OSHA investigator always to go through us. So if we represent you and you get a call directly from the OSHA investigator, we ask you to go through our office. Evidence of damages will be, for example, your W-2 from where you've worked since you were illegally fired, pay stubs. You could be entitled to compensatory damages for mental pain and emotional distress, which might mean copies of prescriptions for antidepressant medication, or perhaps collection notices. If you've been fired and maybe you're now working but you're making half the amount of money, shut-off notices from your utility providers, perhaps past due notices, evidence of your credit report. Those are things that the Department of Labor, either through OSHA or the Office of Administrative Law Judges, if we get to that level, those are the types of things that can show that you're entitled to compensatory damages and possibly punitive damages. So the longest part of the case is going to be typically from the time we file the charge with OSHA till OSHA is done with that. In the next series, we'll start in on the process of what happens once OSHA rules and there's an appeal, and we would go to a formal hearing where you testify live in a courtroom. Thanks for watching. Have a nice day and drive safely out there.